Now, we make two different types of decision in the planning process. One of them is legislative, and the other is applying law or quasi-judicial. The approval of comprehensive plans is always in Florida legislative. Supreme Court, state Supreme Court has ruled that. We didn't know that necessarily when they first adopted 163. The courts had to decide it, had to clarify it. But the legislative, the comprehensive plan is always legislative. Most everything else we do, zoning, variances, etc., are quasi-judicial, because in the case of legislative, we're making the law, and in the case of quasi-judicial, we are applying the law. The rules that apply in the legislative process are much different than apply in the quasi-judicial. The elected body, the county commission, whatever, when they're adopting a comprehensive plan, are making law. When they approve the zoning case, they are applying law. And you may have heard the term quasi ex parte communication. Ex parte communication does not exist related to the conflict. It's not a concept that applies to the legislative process, but it is very important when it's being applied. So the same body, the same county commission or planning commission, when they're looking at the comprehensive plan, they're in this legislative role, and they're looking at the zoning case that applied it or that approved it somewhere down years later, they're in a much different role. I'll expand on that a little bit just a minute. All right, let's look at it. And don't for a minute believe this is a complete course in land use law. I'm trying to touch base on a few key things. This is the Fifth Amendment to the U.S. Constitution. No person should be deprived of property without due process of law, nor shall private property be taken for public use without just compensation. That's where the takings issues come from. Due process of law, that's substantive due process of law. The 14th Amendment the federal government simply said, we can't do it at the federal level, and you folks at the state can't do it either. In other words, every state, no state shall deprive a person of property without due process of law. It's the 14th Amendment. Now, Florida has similar provisions. Article 1, Section 9 says due process, no person shall be deprived of property without due process of law. And eminent domain, no private property shall be taken except for a public purpose with full compensation therefor. I think you're getting the sense of this due process notion and the degree to which private property rights rise to a fairly high level. Now in Florida, we've expanded on that in the legislation. I think this is probably from the Byrd-Harris Act, but it's the intent of the legislature that all governmental entities in the state recognize and respect judiciously acknowledged or constitutionally protected private property rights. And then went on further to say that all the rules, ordinances, regulations, and programs must be developed, promulgated, etc., with a sensitivity to private property rights and not be unduly restricted. Now, if you develop a comprehensive plan considering properly private property rights, then every time you apply the plan, you're not going to have to ask this question. And that's essentially the way most of them are developed. And plans essentially are, I think, those that are developed in the way they should be. This question is constantly there and is addressed in a way that the plans that are adopted, the regulations that are adopted, on their face meet these requirements. Now, the application of them, of course, is another question. And in fact, most issues, I don't recall a case where a comprehensive plan has been challenged because it violated private property rights. There are many cases where someone said, you applied it in such a way to my property that did so. Now, growth management. Important planning and growth management, we lump them together, but they really are slightly different concepts. Growth management actually says that we can regulate the timing and sequence of development and the adequacy of public facilities. remember the importance of concurrency. And that, by the way, gains its authority from the U.S. Supreme Court action in the Golden versus Planning Board of Town of Ramapo, that's New York. Actually, New York Court of Appeals, it was and then upheld by the U.S. Supreme Court, that a municipality could condition development approval on the availability of services. If we didn't have that vision or that precedent, we wouldn't necessarily be able to apply concurrency as a concept. The primacy of the comprehensive plan, I touched on this a few minutes ago. In Florida, the comprehensive plan, the local comprehensive plan, is the centerpiece. Adopting it and amending it is always a legislative decision. We were surprised to find out how much much legal weight that had. Back in 2001, in the Pinecrest Lakes versus Shadell, I think that was in Martin County. Martin. Developer had received approval for a condominium, I believe it was apartments or condominium, knowing that there was a challenge to whether or not that proposal violated the comprehensive plan of the county. It was a setback question. And they went forward to build it with the county in effect saying you do so at your own risk. I think to the surprise of everyone, the Supreme Court, state Supreme Court, not only held for the plaintiffs, which were the adjoining property owners, they told the condominium owners to tear it down. I think those of us, in planning said, they did what? We would have expected, and I think probably the developer expected, he'd get fined or some kind of compensation he would pay the adjoining owners for loss of value or something like that. That was not what they said. They in effect said, you violate the comprehensive plan, and it means what it says. And consequently, that complex was destroyed. Now we also, and I'm again just on touching a few key things, but many times we get involved in planning in who's going to build the roads. Most schools, who's going to build the schools. So we get into this area of exactions. Now what the Supreme Court has said actually in two different cases, one called Nolan and one called Dolan, they didn't plan that out, that's in different places, that if we're going to have an exaction, if we're going to expect a developer or any landowner who's in the permitting process to provide something that's beyond what they actually need, an exaction of building a road or providing a school site or what it was, there's got to be some logical connection between the problem that's identified and the public interest that's identified and the solution that's proposed. And then the Dolan case took that a little further and said there's got to be some rough proportionality between what you asked them to do and the problem that was created. How many of you have heard the term fair share or proportionate share? This is where it comes from. The developer can be expected to provide or pay his fair share, but can you require him to pay more? Probably not. He might be willing to pay more for a variety of reasons, but can he be required to? Now, I talked about this quasi-judicial process and this legislative process. The comprehensive plan is legislative. But when you get to the quasi-judicial part, the zoning part, let's say, again, my 1,000-home development out here, has the comp plan says single family is fine, 4 units an acre. And the developer comes in with 800 homes at 2 units an acre and asks for zoning approval of that. Zoning is quasi-judicial. This is the state Supreme Court in Broward County versus Schneider. The developer must demonstrate consistency with the comprehensive plan. If he does that, for the local government to turn that down, they must, to deny that, show denial, they must show a legitimate public purpose. It's not arbitrary, unreasonable, and substantially and supported by substantial common evidence. In other words, the burden shifts. So the comprehensive plan is where the local government has the authority. They've got very broad discretion in making law, i.e. developing the comprehensive plan. Much more limited discretion in applying that once it's in place. And one of the great difficulties we find in the public process is that the neighborhood comes in at the zoning stage to say we object to the higher density next to our property. And you have to say, but you should have been here at the comprehensive planning stage. And I don't want to talk a lot about Amendment 4, but you're going to talk about it later. But one of the problems with Amendment 4 was, one of the expectations that I think many people had was that we'll get to vote on all those developments. The reality of it is that most developments are not comprehensive plan amendments. They're zoning amendments. In other words, the decision was made usually a number of years in the past. I do work for a little town, High Springs, which is up off Gainesville, and as a planning advisor. And during the bubble, about 2002 to 2007, we actually reviewed subdivision approvals for about 2,400 homes. Now High Springs only has 2,000 homes in it. And the community was upset about that. But only 300 of those were actually plan amendments. That was because they'd been annexed. They didn't realize that the plan already permitted those. They weren't built. I mean, these were speculation. They only had about 100 homes built in that period of time. But the community was upset. Said, we don't want 2,400 homes. But what was the community going to say? The comprehensive plan already permitted those. All those approvals were quasi-judicial. But Brevard County versus Snyder made it clear how this quasi-judicial legislative process worked. It also let me point out too, there was always some question about whether or not zoning was quasi-judicial. And this court case clarified that. Now, if you're going to blanket zones, if you're going to adopt a new zoning map for your entire city, is that quasi-judicial? No, probably not. But it is a fine line. And the difference is, anytime you're applying the law to a particular piece of property or to a few pieces of property, then it's almost always quasi-judicial in the state. Now, it's very important that we understand how this works because it is at the heart of every decision that gets made. When we're doing a comprehensive plan amendment, we're in a much different process. One of the, I'll kind of diverge, but one of the things that I think is a bit hard to get across is when we're in the legislative process, we want people to be talking to each other and to their legislators and whatever. We want a dialogue with them. And then you go over to this quasi-judicial problem, we don't think that's very bad. And it's very hard for elected bodies to put one of those hats on and take it off and put the other on. Very difficult, particularly in small towns. They know all their neighbors, et cetera, et cetera. So it's a difficult aspect of this, but one that's very important that's understood. Most land use decisions implement previously determined policy decisions made in the comprehensive plan and are considered quasi-judicial. Now, who are the guardians of the public welfare? The Chapter 163 basically says that every local government has to have a local planning agency. And they have certain responsibilities. Essentially, they are to be the keepers of the plan, comprehensive plan, to make recommendations and review amendments and so forth. The trouble we have, though, is that the local planning agency, who are the planning officials, could be any of these. There is no clarity in the state law that says the local planning agency must be made up of 9 people who have these kind of backgrounds. Nothing that says that they have to be appointed or that they have to be elected. Nothing that says they have to have training. When we did our training, we've gotten to maybe a few hundred people. There are 10,000 planning officials, and they change all, depending on how you want.